Welcome to another Tomkins Talks, a short snappy summary of an interesting recent case in a format that's easy to digest, whether you're in the office, at home or on the move. Today I'm going to look at the case of Manchester Ship Canal Company Limited and VAUXHALL Motors Limited. Let's start with the backstory. VAUXHALL's Ellesmere port plant is adjacent to the Manchester Ship Canal. Back in the early 1960s, when VAUXHALL was looking to construct its factory, it recognised it would need to discharge surface water and effluent into the canal. It acquired some land for this purpose, but also needed to enter into a licence with the canal company, which permitted it to discharge surface water into the canal in perpetuity for an annual fee of £50. The licence set out that if VAUXHALL failed to pay the licence fee within 21 days of it falling due, whether that sum was demanded or not, the canal company could give notice to VAUXHALL, requiring it to pay the sum in 28 days. And if it failed to do so, the canal company could give notice to determine the licence. You can probably see what's coming, but VAUXHALL failed to pay the £50 licence fee due in October 2013 and still failed to pay following notice from the canal company. As such, the canal company terminated the licence. The parties initially entered into negotiations for a new licence but could not agree terms. The canal company, perhaps considering it was in something of a strong bargaining position, sought to increase the licence fee from £50 to £500,000. In response, VAUXHALL made an application to the court for relief from forfeiture. The canal company argued relief could not be granted as the 1962 agreement only created a licence. So what was the outcome? The High Court found in favour of VAUXHALL. It was satisfied that although the licence did not create any proprietary rights, relief from forfeiture could apply where there were sufficient proprietary rights, and this was a case where relief should be granted. The canal company applied to the Court of Appeal, who dismissed their appeal, agreeing with the High Court's decision. Perhaps unsurprisingly, given the potential upside to it if relief could not be granted, the canal company appealed to the Supreme Court. Lord Briggs gave the leading judgment and confirmed that relief from forfeiture could be available in relation to a licence and should be available in this case where a licence had been granted in perpetuity. As such, the canal company's appeal was not successful and the licence would resume, with VAUXHALL having to pay just £50 per annum to the canal company. So what does this mean? Well, relief from forfeiture is not confined to leases and can be available in connection with licences. However, this is not a blanket rule, and it will depend on the nature of the licence in question as to whether relief will be available to the licensee. Please feel free to comment on or share this video, and do get in touch if you would like any more information on it. I'll see you again soon for another Tomkins Talks.